Hello, hello, everybody. Happy Thursday. Thank you for joining us at Humi. Very excited to talk to you all about navigating employee leave types. We're just letting people into the event. So if you don't mind, we'll start around 1:03 p.m. Eastern Time. I would love if you could drop in the chat where you're joining us from so that we can get an idea of what the participation location looks like. All right, loving it. Toronto, Edmonton, Halifax, lots of different time zones here. Ashley's joining us from Sudbury, Vancouver, Montreal, bonjour. Okay. Both Matthew and I are here in Toronto. I'm looking at some lovely condo buildings in the concrete jungle, and Matthew's got his beautiful painting in the background and tree to the left of him.
As I look out on an empty downtown Toronto.
Yeah, well, it's a nice day in Toronto, at least.
Yep.
Okay, so just another 30 seconds here. Thanks for dropping your location into the chat, everybody. We have somebody joining from Waterloo, my hometown. I love that. Hamilton, Niagara Falls, New England in the US.
Wow.
Lots from the West Coast. I'd love to see it. Banff, Alberta. Okay. Well, we're going to jump in and get started. Thanks again for everybody sharing your location. Again, it's always really exciting for me to see. I love to know where people are joining us from in this remote environment, different time zones, different locations. It's very exciting. So thanks again for joining, for logging in. I'm very excited to talk to you today with Humi at this webinar talking about navigating employee leave types. So to recognize this day, I'd also like to recognize our land. So in terms of our land acknowledgement, we recognize the original stewards of the land which we are on, albeit virtual. It's important to acknowledge that we are living in a path forward towards truth and reconciliation. The city of Toronto, which is where myself and Matthew are joining from, acknowledges that we are on the traditional territory of many nations, including the Mississaugas of the Credit peoples, and is now home to many diverse First Nations, Inuit, and Métis people. As many of you know, you can see myself and Matthew are wearing orange in recognition of the fact that today is National Truth and Reconciliation Day. And we hope that for those who do not identify as Indigenous or someone who is impacted by residential schooling, that you are taking the time today to learn, to educate yourself and your teams, and to reflect to build a path forward towards truth and reconciliation. So I'd also like to take some time for some additional acknowledgements here today. So I'd like to take this time to acknowledge the important people and teams working with us to host this event. Firstly, I'd like to call out My Friendly Lawyer. They are working to level the playing field in the legal space. My Friendly Lawyer is a professional legal hotline with a dedicated Canadian network of lawyers that work to provide coverage and advisory services with unlimited 24/7 calling in both French and English. Thanks to My Friendly Lawyer, we were able to connect with Matthew today. And the next acknowledgement is a shout out to Humi's content team. So I'd like to thank our content marketing team who has been working behind the scenes to launch this webinar, and who is the dream team that's moderating the chat, flagging questions to myself and Matthew, and bringing us a great online webinar experience. So let's talk about a rundown of this event and why we're here today. Before I introduce our excellent panelist, let's talk about that. So many Canadians have continued to endure significant lifestyle changes over the course of the pandemic. I think that we're all a little sick of hearing the word unprecedented, but it truly does capture the environment that we're currently working through. The lifestyle and accommodation needs for your employees may look a little different than what was requested pre-pandemic. And we know that by navigating employee leaves can be very stressful without access to an employment lawyer. And that's why here today, Humi is bringing you access to Matthew Wise, partner at Toronto-based law firm Macdonald Sager Manis LLP. Matthew, can you introduce yourself?
Thank you, Andrea, and I'm honored to be here on National Truth and Reconciliation Day. My name is Matthew Wise. I'm a partner at a firm in downtown Toronto called Macdonald Sager Manis. We're a full-service firm, but my practice is almost exclusively limited to employment law. I've been in practice for over 20 years, which is hard to believe. And I will say that in my 20 years of practice as an employment lawyer, the issues surrounding the vaccines and COVID are amongst the most difficult and the most interesting issues I've come across. As Andrea mentioned, a lot of the issues that we're going to discuss today are in fact unprecedented in that they've never been opined upon or decided upon by a court. And therefore, people like Andrea and myself are going on some educated guesses and some analogies to what's happened in the past to make some decisions and recommendations as to how courts in the future are going to deal with some of the issues surrounding COVID and vaccine mandates and leaves of absences, which I'm sure we'll get into in more detail today. That being said, I'll throw it back to Andrea, and I believe we're in a position to start the Q&A.
Yes, we are. And again, folks, my name is Andrea Bartlett, and I am the Director of Human Resources here at Humi. And so in terms of some of the logistics for today, so feel free, at the bottom of your screen, you'll see a function that is called Q&A. So I know at the beginning, I asked you to drop your location in the chat. If you can actually use the Q&A function, that way the team can either respond directly or pass the questions to myself so that we can have them answered by Matthew. Feel free to use this time now to submit any questions that you might have to myself and to Matthew. And while folks are submitting their questions, I'm going to jump right in with some questions that were actually emailed to us at Humi before the webinar started. So Matthew, this question is around disability or medical leave. So the first question reads, can an employee on disability or medical leave be fired?
This is a question I'm asked all the time, and I often point out that the question is not asked correctly. Can the person be fired? The short answer is, of course they can be. Anyone can be fired at any time. It's a common misconception that it's very difficult to fire people in Ontario. Unfortunately, it's not difficult. It's just very expensive. So to your point, Andrea, when someone is on disability leave, the law is very clear that that person's position with their employer shall remain the same and unchanged. And upon them becoming better or them returning from sick leave, they are by law entitled to return to the exact same job they were in prior to the leave, unless that job no longer exists. And if they are not returned to that job, or they're returned to a different, lesser job, depending upon the circumstances, they may be able to claim for constructive dismissal, but they also would be able to claim for a breach of the statute. And as well, it may give rise to a human rights complaint, because disability, broadly defined, is a protected ground under the Human Rights Code. And the rules and the decisions are analogous in that you must be placed exactly where you were. Similar to a maternity leave, I sort of always say to clients, it's almost like when you go on leave, your employer presses pause, and then when you come back, they press play, and nothing has changed. And that's what you have a right to. The philosophy is no one in this province ought to get punished for getting sick. Getting sick is beyond your control. And if you're on a leave of absence and the prognosis is that you're going to return, you should be able to return to the exact same job that you had.
Okay.
And if you don't, then you would be entitled to wrongful dismissal damages and likely additional damages under the Human Rights Code.
Okay. And that you actually touched on a question that actually relates to parental leave. So similar question, can I terminate an employee on parental leave? If so, how?
The how's the easy part. You send them a letter saying you're terminated effective immediately. Your severance is this X amount of severance, but don't be surprised if you get a lawyer's letter back in return that quite clearly states the obvious, which is the statute, the common law, and the human rights code basically say that all leaves are job protected leaves, and you ought not to be fired or punished for getting sick or for one of the partners taking some time off to be with a newborn child, etc. So that the short answer is that yes, you can be fired, but you would be entitled to almost certainly some additional compensation. Now, again, unless that job no longer exists, an example from the real world that we had is in my office, we had a partner who had an assistant. That assistant went out on mat leave. During her mat leave, the lawyer who she worked for left the firm to go work for a bank. We were a very small firm at the time. We had no other position for this person. The job was eliminated. Now, of course, we had to pay her all requisite severance, but that was an instance where the job no longer existed. But in any other instance, you are entitled to return to the same job you had prior to the leave.
Okay. And does it have to be the exact same job or a similar job?
I mean, everything there is some subjectivity, and certainly these days, given how much the economy and the workplace has changed. For example, someone who may be returning from a mat leave next month, it's a very different environment than it was before they left. So it's similar. It is similar.
Okay. Okay. Now you mentioned severance. The next question that I have reads, what is the difference between termination pay and severance pay?
Okay, I can explain that one. They both are, and this is tricky because people use the term severance much more broadly than what it actually means. There's three entitlements to pay that someone can get when they're fired. There's termination pay under the statute, which everyone gets. It's under Section 57 of the Employment Standards Act, and it says a employee is entitled to 1 week, a minimum of 1 week's notice per year of service, up to 8 weeks. That's called termination pay. It's a defined term under the statute. Further down in the statute, under Section 64 of the Employment Standards Act, is something called severance pay. And to qualify for severance pay, two criteria need to be met. The employee needs to have been employed for 5 years or more, and the employer's payroll needs to exceed $2.5 million. If both of those criteria are met, then the employee is entitled to an additional 1 week per year of service, up to a maximum of 26 weeks. For example, take a 10-year employee who works for an employer with a payroll in excess of $2.5 million. They would get a minimum of 8 weeks termination pay, and then, which is the maximum. And then because they were 10 years, they would get an extra 10 weeks of severance pay for a total of 18 weeks pursuant to the statute. Now I can jump ahead to the next question about are there entitlements over and above the statute? Do you want me to address that? I'm guessing that's somewhere down there.
Yes, I think that is a perfect segue.
Okay.
I have some follow-up from what you just outlined, but let's go there first.
So basically the statute makes it very clear that it's a minimum requirement. And the law has made it very clear that you cannot contract out of the statute, but you can, as an employer, put an agreement in place that entitles the employee to only what's in the statute. And as an employment lawyer, and to all the employers out there listening, if you don't have an agreement that says that, you should. And here's why. Because if you don't put a hard cap on your entitlements, then the court will look to a number of other factors to add on, taking our example, to the 18 weeks that the statute gives this terminated employee. And they will look at a number of factors, the most important of which are age, years of service, and to a lesser extent level within the organization. So let's take our 10-year employee. Let's say, for example, that 10-year employee was 62 years old, was the senior vice president at a bank making $250,000 a year. That employee is going to be entitled to, in my view, at least a year of notice or payment in lieu of notice. So the difference in terms of having a clause in your agreement can save the employer a lot of money, because the common law is very generous to employees. They employ what I think is some fairly sound logic. If you're 62 years old and you've been with the same company for 40 years, your prospects of reemployment are somewhat different than a 32-year-old who's bounced around from job to job and is only with the employer for, say, a year and a half. That person can go out and replace their income much more quickly, in theory, than the 62-year-old who's been with the same employer for 30 years. So the answer to your question is termination pay is up to 8 weeks pursuant to the statute. Severance pay, if certain triggers are met, is an additional up to 26 weeks. And then there's a common law, which is more subjective. It's more of an art than a science, but it's very generous. The general rule of thumb is, in certain instances, close to a month per year of service. So a contract can save an employer a lot of money, in both in severance and lawyer fees.
Perfect. And to be clear, those three things that you mentioned for severance, it's gross annual payroll of over 2.5 million.
Yep. And over 5 years of employment.
Over 5 years of employment. Does company size have any bearing on severance pay and whether that's a factor?
In terms of number of employees?
Mm-hmm.
Well, I mean, only to the extent that the more employees you have, the more likely you are to get to that $2.5 million threshold. They've decided to do it by payroll as opposed to number of employees. The rationale being, or at least as I've always understood it, was if your payroll's over $2.5 million, you've got enough money to support these employees you're terminating,
Mm-hmm.
right? The thinking is if you're a really small company, they don't want to overly burden small companies with notice obligations. So for whatever reason, they set that threshold at 2.5 million. And if you're there, then you have to open up your wallet a little bit more.
Mm-hmm. Now, obviously, we're talking about termination. You mentioned employment agreement and termination clauses. Mm-hmm. That's often the least looked at part when someone's joining a company. You're excited about the future. You're not thinking about the end. But is there anything, in the last year that has changed within the employment law landscape that impacts termination clauses that you think that HR professionals should be aware of in terms of the enforceability?
Absolutely. Absolutely. For the past 5 or 6 years or so, there's been a steady stream of cases that have come down from the Superior Court attacking termination clauses and basically saying if your termination clause in your agreement is not perfect, for lack of a better term, then we're going to scrap the entire agreement and just give the employee their common law notice. So any protections or any caps or any limits that you try to impose by putting in a termination agreement, the courts are looking for ways to void them and have come up with a number of, in my view, incredibly creative ways to tell the employer that they have to pay more money, notwithstanding that their agreement is written in crystal clear English and it makes total sense. They basically hold employers up to a very difficult standard, to the point where it's arguable that just about any employment agreement out there that's a few years old probably would be subject to at least an argument that it's void based upon how the courts have decided over the past couple of years. It's a really dangerous situation in that, like I said, anyone who's got an older employment agreement may find themselves not as protected as they had thought that they were. So certainly if one piece of advice from today to any of the employers listening is take a look at your employment contracts and if they haven't been edited or reviewed in a while, probably best to get someone to have a look at them to make sure that there's no pitfalls based upon what the courts have said. I can give some examples, but I don't think that's necessary. Obviously, it's the cases are out there. They've said some very, what I think, counterintuitive things, but all that's a very long way to say, yes, things have changed, and courts are protecting employees more than ever.
Okay, now just on, before we wrap up that thought there, in terms of advice for how to manage what is reasonable consideration, right? You talked about the changes in the legislative landscape. There's clearly a lot of risk for employers with the enforceability of contracts, including the termination clause in contracts.
Yeah.
For employers and for HR professionals who maybe this is new information, or maybe they're thinking, okay, now I know this, what do I do? Can you talk about consideration and what types of consideration is important to think through when going through this exercise of reviewing and then maybe extending updated agreements to employees?
So that's another, it's a very, very good question. And it is one of the questions that we don't really have a good answer for. Because another thing the courts do, it's very difficult to amend an agreement midway through an employee's tenure without giving them something in exchange, consideration. And generally you need to, if you're going to take something away from an employee, you need to give them something in return. So it's a bit of a case-by-case basis. If an employer comes to me and says, this is the agreement that all my employees are under, and it is well worded enough that it's only the recent changes that require the amendment. In other words, if the change is only clarifying something that they otherwise agreed to, it's a lot easier to do. If there's no such clause, or the clause is clearly deficient, it's going to be a lot harder to say to an employee, we're taking away your common law rights without giving them something in return. And what that something in return is kind of depends on a case-by-case basis. It generally needs to be balanced. The problem we run into a lot is if you have an employee who's been there for 15 years and doesn't have a contract, and now you want to get them under contract to sort of limit your rights if or when you need to terminate them, that's a lot harder to do, because for the very obvious reason is you're asking the employee to leave money on the table. And as you mentioned earlier, Andrea, these are not things that employees typically turn their mind to. They really don't. I mean, I can't tell you how many times I've had terminated employees call me and I say, oh, is there anything in your agreement that speaks to termination? And they say, oh, no, there's nothing. I say, send it to me. And they send it to me. And sure enough, it's not there, and clearly, but it's there. You just have to sort of look for it. So it's the courts have made it very difficult for employers, not impossible, but difficult.
Okay. One question here is, are you quoting federal statutes or provincial statutes?
Oh,
I just wanted to clarify.
I'm sorry. When I say statute, I'm referring to the Ontario Employment Standards Act 2000, which is what applies to the majority of employees in Ontario, and the provincial statutes throughout the country, with the exception of Quebec, are relatively similar. And as far as the federal labor code goes, it's similar but different. And it only applies to certain, a small sector of the economy, airlines, like Rogers Bell, the airlines, telecommunications, some shipping, planes, trains, and automobiles kind of thing. But the vast majority of employees that are non-union would fall under the Employment Standards Act of Ontario, or of their respective province.
Just wanted to confirm, because of course we have people joining across the country, but for the most part,
that is an important distinction. I should clarify that everything I've said thus far is as it pertains to the Employment Standards Act of Ontario. My understanding is that, again, the provinces, with the exception of Quebec, are relatively similar, but they do or they may not have the same rules. Like I quoted the specific section 57 and section 64. They're all relatively the same. The numbers and thresholds might be a little bit different.
okay.
But that is an important thing to point out.
Yeah. Okay. Now we're sticking to some termination questions still, because there's some tactical things that I think are really worthwhile digging into. Just right off the top, of course, when we talked about some of the testing for severance, we talked about $2.5 million. That relates to payroll. Can you explain what that means and give a little bit more context and clarity around the $2.5 million threshold? How would an HR professional go about, and why does that number specifically matter to them?
Well, I mean, first of all, it's a good question, because there's been a ton of litigation on it, because it ought not to surprise anyone listening that a number of bigger companies will run their organizations through any number of subs and holding companies and et cetera, et cetera. The courts have generally looked through that to see, they say, who's really running this business? Is it being run from the top of the pyramid, or are these truly independent businesses? And you simply you simply look at your books and records, see what your payroll is for base salary, commissions, and bonuses for all employees. And if it's over 2.5 million, it triggers that number in the section. As to why, as I mentioned before, probably it's a number they chose at random. Well, not at random, but as I guess they picked a number that would be high enough that the employer can afford it. And that's where it comes from. It's right in the statute. The statute says if you meet these two criteria, the following entitlements will apply. Okay. Does that make sense?
Yeah, and you mentioned subcos and things like that, which, for some of the listeners might be very much a pain point that they're navigating. For others, it might be a totally foreign concept. But can you explain, what if the parent company has over 2.5 million in annual payroll, but the company or the subcompany that the employee works for does not? Right. What are the obligations there?
There's a lot of litigation on this. And I was just at the Ministry of Labor on a similar situation. It really depends on how different the two businesses are. If they're two completely different businesses that are run by the same parent, but they do two different things, it's more likely a court would find that they have two separate payrolls. If they're really doing the same thing and these corporations are set up for corporate structuring reasons or tax reasons, but ultimately the money's going to the same place, the more likely they'll find that, no, it's all one big entity, and therefore you pass that threshold of the $2.5 million. There was a case like 2 weeks ago that kind of put this in flux, but the gist of that case was, if we can find a way to add up all the different payrolls, we're going to do it, basically, is the message that I got from the Ministry of Labor about 2 weeks ago. And when they told me I was wrong in my math.
Well, would you say then, Matthew, that the same legislation applies for not-for-profits who have higher payroll numbers?
I'm not 100% sure if not-for-profits would be an exemption. I'm not sure as I sit here. I think that if the payroll has always been the trigger, I don't know if there's exceptions for not-for-profits. I imagine if their payroll is 2.5 million, they might not. But I can't say for sure as I sit here today whether there's a specific exception for nonprofits.
Okay, I have two last questions around termination. Then we're going to segue into leave types and end with COVID. So one of the first questions actually comes up often as HR professionals or employers. You type up the notice letter that someone is being terminated, and sometimes the reasoning is vague or it's very, very specific.
Mhm.
So the question is, can an organization simply claim the dismissal or the termination is because of restructuring in order to avoid any legal implications? And what are the risks associated with doing that?
No risk. Restructuring is one of the more common reasons. It's often extremely broadly defined, but it's important to note that the reason actually doesn't matter unless you're terminating someone for cause. Then it becomes a little bit more important. But whether it's restructuring or otherwise, I generally apply to the school of thought that less is more in the termination letter itself. Obviously, during the exit interview, if there were issues, they can be discussed. But if it's simply a restructuring or a shortage of work, that's frankly the most common. It triggers the easiest entry code on the record of employment and is the easiest way for that terminated employee to get EI. It is the most common, I would say. And it's the sort of catch-all when, it just didn't work out kind of thing. But there's no real risk. There's only two ways to fire someone: with cause or without cause. If you've got cause, which is almost impossible, you don't owe them anything. If you don't have cause, then you owe them what you owe. There's no middle ground for kind of bad employees. If it's restructuring, if they're incompetent, if they're insubordinate, if you don't like their shoes one day, doesn't matter. It's all in the without cause termination, and they're entitled to their severance, depending upon the factors we discussed and or whether there's something in their contract that speaks to it in terms of entitlements.
Okay. Now you said something interesting there before I jump to the next question, that the two ways are with cause or without cause, and with cause is almost impossible to prove. So can you elaborate on that? Because oftentimes when businesses are looking at cost, sometimes you end up with this, with the tendency to go looking for a specific reason. And is this a big enough reason that you can terminate someone? Gross misconduct, how is that classified, as an example? Can you just elaborate on why that's so hard to prove?
Sure. Well, you're going to sense a theme here. It's so hard to prove because the courts have made it hard to prove. Basically, the courts have defined just cause extremely narrowly. Insubordination is not it. Gross insubordination is not it. Incompetency is not cause. Stealing, harassing, obviously any inappropriate conducts that would speak to some protected grounds in the Human Rights Code, those can trigger a summary dismissal. In other words, get out now for cause. It has to be very extreme, though. You would be shocked at the types of cases and the types of things employees have done, and the court said, yes, they shouldn't have done that, but it's not cause. So you always have to operate under the assumption that unless the employee is legitimately stealing from you or something extreme, you're going to have to pay severance. Now, if you have there are ways to send warning letters, and then you can sort of paper the file to lead it up to a termination with cause, but it's tough. You need a fairly specific fact scenario to apply cause at law, and that's because the courts have narrowed the definition so significantly.
Okay.
And there's no gray area, so it's all or nothing. Either you have it or you don't.
Yeah. Okay. Thank you. So this next question is around terminating someone for the reason being that the position no longer exists.
Yep.
So the question then says, how long needs to pass before a company can reintroduce this position without having any sort of legal complications or obligations?
Arguably, immediately. Again, it goes back to what I said earlier. you can fire someone in Ontario anytime you want, for any reason you want, outside of a protected ground, provided you give them enough notice or payment in lieu of notice. In other words, as long as you pay them off enough, you can fire them. And if they subsequently come back and say, well, you told me the position was being eliminated, but then you replaced it, I suppose it could give rise to some additional damages, but generally speaking, no, you're entitled to fire someone and replace them with someone else. It goes back to what I said earlier in terms of communications during the termination. Less is more. If you didn't fire them because you eliminated the position, knowing or knowing that you're going to hire someone else, don't say it, because although I don't think it could give rise to much liability, even if it couldn't, you still may get a lawyer's letter that you have to deal with, even if that allegation doesn't carry much weight. It's just one less hassle. So I guess if you are truly terminating someone because the position no longer exists, and then 2 weeks later you get in, whatever your business is, you get in a big file or a big order and to rehire somebody, you can do that. You can call the other guy back and rehire him or her too. You can do any of those things, but there's no specific requirement to, if you fire someone because the job is eliminated, you don't have to wait a certain period of time.
Okay. Again, something that came to mind for me while you were talking, that I often am in a position where I'm talking to, whether it's hiring managers, new managers, and the concept that less is more.
Yeah.
But as humans, whether you're
sure.
a people manager, employer, human resource manager, oftentimes you're in a position, especially in a remote environment where you're on a video call, it's very cold when you have to terminate someone, whether it's on the phone, video, or in person. Any advice on an elaboration on less is more when you are communicating termination to someone? Because there's a natural tendency to want to explain, and usually the individual being terminated wants to know a reason or wants to know more information. So what advice do you have there?
Well, I mean, my advice generally, obviously it's case specific. My advice, and I've, as you know, I'm a partner at this firm, I have not only given advice on this, I've done it a few times, unfortunately, and I've done it over Zoom, is you tell the person, we've made a decision to terminate your employment. We're really sorry. I'm gonna email you a copy of the termination letter after this meeting. Take some time, think about it, and then if you have any questions, you can call me. My experience, both my experience and sort of what I've been told in speaking is once they hear terminated, they sort of go blank. They don't really hear anything else, and at least in my experience, is they just want to get out of that meeting or out of that office as soon as they possibly can. But you're right, Andrea. Some of them will want to engage, and I guess it really depends on the meeting, on the reason. If the person is incompetent, they weren't doing well, you don't need to use those words, but it ought not to come as a surprise to them. If it's shortage of work, it's shortage of work. I guess the answer, from your perspective from HR, I mean, you are under no legal obligation to give them a reason. In terms of how you manage them, I guess it really depends on the employee, and it really depends on the reason. Obviously, you need to be delicate. I mean, if the person was just a complete incompetent, that's not really the time to point that out to them, how incompetent they were. No point kicking someone when they're down. But again, rip the Band-Aid off, try to make the meeting as short as possible, let them collect their thoughts, and if they have any questions, then they're going to ask. And if the truth is the truth, then tell it like it is. But generally speaking, if you just didn't like the person, then it just didn't work out. Wasn't a good fit.
Yeah. Okay. And in terms of best practices, you had talked about before you get to the point of termination, do you have what best practices do you recommend in terms of documentation, notices of performance, disciplinary measures in writing, to minimize the risks of wrongful dismissal exposure or additional termination or severance pay?
Right. I mean, ultimately, it doesn't matter because if you fire someone without cause, the factors that we discussed earlier are going to go into determining the appropriate amount of notice. However, if you do have an employee who is continually making mistakes and or not doing their job properly, going back to what I said earlier, I mean, you are entitled to send, like, it is a good idea in most instances to send a disciplinary letter if someone is really not doing their job. But there's a way to do it, because in theory, you could use this as a setup or as a way of papering your file towards a termination for cause. Because I suppose I should go back and say you can terminate someone for cause for incompetence if it's extreme and they've been warned in writing more than once. See, like the courts sort of, like I said, they make it really hard on employers. So you have to send one warning letter saying, here's what you're doing wrong. Here's what you need to do to fix it. If you don't, there may be further disciplinary action. And then if a month you reassess and they're still not doing the job, the more there is on writing evidencing their poor performance, the more you may be able to establish a case for cause. But to your point, Andrea, it takes time, and it does take things in writing to, for the employer to come back and say, no, I told him he was doing it wrong or she was doing it wrong 100 times. And I say, show, don't tell. So yes, putting things in writing, even if it's an email, is a good idea. But that goes more to your expertise, Andrea, in terms of wording, balancing, tone, language, things like that. The only thing from a legal perspective is if you do have a poor performing employee, you want to include language that explains to them that if there's not an improvement, a termination is a possibility. So, but other than that, there's no real magic to it. And unless they're really bad and you think that a termination for cause might be likely, then a warning letter would be appropriate in those circumstances.
Mm-hmm. Okay, we're going to segue into about 6 or 7 questions that we have around leaves and vacation. But before we get there, can you start by explaining how a person qualifies for employment insurance, EI?
Someone, basically what happens when you get terminated, your employer marks a code on your record of employment, and you basically, unless it's termination for cause, which is a certain code you put on a record of employment, or they quit, then they simply take the record of employment and file it with Service Canada, and they get in the queue for EI. Now, their severance, the severance that they receive will impact timing of their EI. For example, if you get fired on January 1st and they give you 6 months of severance, so you're on the payroll for the next 6 months, in theory, your EI wouldn't start until July 1st of that year, until the day that you stop receiving money for severance. Then the government will step in and not fill that void, or fill a portion of that void.
Mm-hmm. And now an employer does have 5 business days to submit that ROE, or record of employment, right?
Correct.
Okay.
Correct.
I think that's often something that is asked about.
It's something that's often forgotten by the employer. I can tell you that.
Yeah. Okay. So certainly not at Humi, not in our payroll system.
No,
but I can say, yeah, that is an important piece and often forgotten about, whether it's EI because of termination, or somebody goes on a job protected leave and the employer is required to submit that ROE so that they can start collecting EI.
That's exactly it. Any kind of leave of absence would be evidenced by an ROE that goes to Service Canada.
Exactly. So this question's on maternity leave. So what if someone went on maternity leave as part of a reorganization prior to their leave? They signed papers that they will be supported until their leave ends, and that they will get their severance payment once the leave is completed. But they find another job while they're on maternity leave without telling the company. What are the rights of an employer in terms of benefits and paying out the severance?
The devil's in the details with that question. It would depend on exactly how it was worded. If this employee did find the new job while he or she was off on a leave related to the birth of a child, then they've mitigated their damages. Presumably with the new job, they're going to go on benefits, and you cannot be on two people's benefit plans at the same time. So that could cause some problems. And essentially what happened is this employee quit and took a new job. In this instance, it's a little bit different, because I think she would have, or he or she would have, an argument that they're entitled to their statutory pay, which is not subject to mitigation. But because they were on leave, technically speaking, they just quit. Technically, they quit as of the day of the leave. I mean, in the eyes of the law. So I think they would have a hard time getting their severance in that situation, or at least the full severance. But it would depend on the wording.
Okay.
But essentially, she quit, and when you quit, you don't get your notice because you've replaced the income.
Mm-hmm. Okay. Now, this next question has to do with short-term disability.
Mhm.
If an employee is taking a short-term disability leave, are they expected to exhaust all of their paid sick time before applying for EI?
I don't think so.
And that's more the details of why, what type of leave they're taking, or?
I think it depends on what kind of leave, but a short-term disability leave is for something completely different than quote unquote sick days. They're different, protected. They ought not to overlap. The employee ought to retain their sick days if they're off, because a sick day is not a leave of absence. It's just a day where you're not working, you remain on the payroll, nothing changes. A leave of absence is a formal cessation of the employment relationship as evidenced by the record of employment, and that employment relationship remains broken until that person returns, as opposed to a sick day, which is merely a payroll adjustment. So no, I think is the answer to that question.
Okay. And this question has come up a lot, especially with COVID. People were not taking vacation. Of course, people can travel.
Yeah.
So this question reads, are we required to pay for vacation if employees do not take their vacation allotted to them during the year? And a follow-up, what are some of the options of how we can treat vacation?
That's a very good question. And I get asked that question a lot. I unfortunately think you have to pay it. But it remains a bit unclear. There's a lot of talk of a regulation coming into place that's going to address this, because it is a bit nebulous, and vacation is a bit of a tricky concept to begin with. And then, of course, there's the people who, or find themselves in a hybrid position, who can sort of work, but they can work from home, as opposed to people like who can't work at all. The short answer is I do think the government is going to have to come in and answer that question better for us, because I think employers are going to find themselves with big bills at the end of the day that they weren't expecting. But I think unless something's done, I think the employers are going to have to pay it out.
Now, what about forcing this notion of employers forcing employees to take vacation? Is that something employers can do? I
think so. I think so, because essentially, if you have 2 weeks vacation, you're being paid for 50 weeks, and the 2 weeks are basically your own. So I would think that you could schedule you could tell them to take vacation, as opposed to saying you can't just sort of bank it and wait until the end of the year, or keep banking it and banking it. I think especially in COVID, I know at the beginning of COVID, a lot of employers and employees were using vacation days at the beginning, so they could keep getting paid before they had to go on an actual leave. So I know a lot of people exhausted their vacation days, but of course, 18 months later into another calendar year, and now we're almost into another calendar year, there's going to be some big accumulation there. So it is a live issue. My fear is employers are going to be stuck with it. I'm hopeful that the government will provide some clarity as to what we're supposed to do.
Okay.
It's also harder to track. It's also been a lot harder to track over the last 18 months. So.
So then can a company, as a follow-up, can a company mandate that a person take vacation before it expires? So it sounds like you can.
I think that I think that you can. I
Okay.
think that you can. I know some people disagree with me. I think that you can. In my view, from what I've read and my experience, I think that you can.
Okay. And last question before we move on to some of the COVID questions. So one of the participants says that when they've spoken to Service Canada about an employee who is on a sick leave, they've required the company to pay out all sick days before the government would cover them on EI. Does that sound bizarre or unexpected? Sounds like yes.
Yeah, it does a little bit for the reason I said before. Well, hold on. No, what we were before, I said that in the context of short-term disability leave, which is something completely different. That is a statutory leave of absence covered by an insurance company as opposed to a sick day. So there's something like, I guess maybe we're not using the term. So they're going on sick leave. So they're going on disability. So because there's a difference between going on disability leave through Service Canada as opposed to going on short-term disability through Sun Life.
Yeah.
For example. So I think in that situation, I think that the government would want sick days to be used before the person can apply for EI, because technically they still have the ability to get paid before the government's going to pay them, which is different than if you're going through insurance, because sick days and STD are two different, short-term disability are two different things. They're two different types of days off, I guess.
Yeah. Okay. Okay, so moving on to COVID related questions.
My favorite topic.
So this participant says, we've been subcontracted by a company from the United States who has said that only vaccinated employees from the company can work on their sites. Any risk to our company in holding the employees to this?
So the question being, it's a US company, has a vaccine policy, but they have operations in Canada. Can they impose a similar policy? My first question is, what type of business is it? I don't know if we can respond. Okay, so I guess we can't. The short answer is yes, you can. If it's a private business and you don't want unvaccinated people to come into your business, you have every right to do so. The federal government has said it's okay. The provincial government has said it's okay. The municipal government said it's okay in certain sectors. Obviously, the more forward-facing your business is, the more reasonable it will be to ask people. If you run a law office, like I do, we have a vaccination policy. We don't, we either require proof of vaccination or a negative test. But if you're in a manufacturing plant, no question. There's no question. You have a right to do that. And you have a right, and you also, as an employer, arguably have an obligation. You definitely have an obligation, whether that to keep a safe workplace. Now, whether that extends to keeping unvaccinated people out of your workplace has not been decided upon by a court or a tribunal. But to me, I'm guided by what the government has already done. The federal government has imposed those types of vaccine mandates. So I think it would be difficult for a court to say that if this client who we're speaking of from the US said to their Canadian employees, we have a vaccine requirement as well, you must show proof of vaccine before you come into our offices. I don't take issue with that.
Okay. So on that, you mentioned you have a COVID policy. One of the participants says that they're currently working on a mandatory vaccine policy for their workplace. What is the best way to implement it into my workplace if we shift to that model?
No simple than any other way that you would communicate something company-wide. I spent the last month or so, I've written dozens of these vaccine policies. They're always fairly specific, obviously tailored to the industry in question, and some people are more liberal than others, but it depends on the organization. For my firm, we have about 70 employees, including lawyers. Sent an email, please find attached the vaccine policy effective October 31st. I think it depends with each workplace. The bigger the workplace is, the suggestion, at least my suggestion, would be, in addition to emailing it to everybody, post it in various places around the office or the premises or the workplace. If it's kitchen, post it in the kitchen. You know what I mean? The whole point, the only point of it is the employees always need to know what their requirements are. And if they choose not to, then the next question is, well, what can we do with them? And that depends on a number of factors as well. I literally, before we signed on today, I saw that 600, I think it was United Airlines employees got fired because the vaccine mandate is coming into effect and they're not vaccinated. And everyone's saying, oh my God, they fired 600 people, but they have 67,000 employees. So that means their vaccination rate at United Airlines is about 99.5%. But the decision was made, albeit in the United States, these people are fired, full stop. University Health Network in Ontario has said the same thing. If you're not vaccinated by, I think it's October 31st, you go on unpaid leave of absence for 2 weeks. If you don't get vaccinated in those 2 weeks, you're fired.
Okay.
Now, could a law firm get away with that? Is it, or an office setting, could they get away with that? I have a short and a long answer to that too, if you want me to get into it.
Mm-hmm. Well, we have one more question. We do have to wrap up because we have 4 minutes. Time has flown by. And I will also say, you talked more about the physical working space, and certainly many of our participants are shifting or in the midst of shifting to hybrid or remote first. And so using your HR system, whether it's something like Humi that allows the employees to acknowledge that they've seen a policy, would that be something that if you ever had to prove, even if they didn't sign it, but there was a system that could prove that they had viewed a policy and acknowledged it, is that something that you could argue?
Probably not. I think it would be very hard for an employee to say that they just didn't check their email. Presumably you'll send, or the HR person will send one, and they'll send a follow-up a week later. Please be reminded. Every other single person there is going to be talking about it. They're going to know about it. I think it would be very difficult. Oh, I lost my screen there. Can you guys still see me?
Yeah, we're still here.
In any event, I think it would be very difficult for the employee to argue that this was just sprung on them and they had no clue. I don't think that argument would have much credibility. I suppose we could think of a hypothetical where it would, but I think that would be a very difficult argument for an employee to make.
Okay. And before we wrap up, Matthew, this last question has to do with testing positive in the workplace. So this person had a positive COVID case in their workplace. What is their obligation to disclose to employees or clients who may have been in close contact with the COVID positive employee versus the obligation to maintain employee privacy?
I think you do have an obligation. I think this is more of a question that public health would be able to answer. I'm not sure what the legal obligation is, but my understanding with any business is you have to track anyone that comes in, or at least you have to have them submit the form that says they don't have any of the symptoms. That way you have their information. And if they were exposed to COVID, I think you would have to tell those people because, take for example, in my office, let's say I find out today that the person in the office next to me has COVID. Well, I would have to quarantine, and I would have to tell everyone, everyone in this office in theory would need to quarantine. I think that's what public health is saying these days. But I can tell you, my view is that public health will trump privacy. In this instance, you don't need to give the employee's name. You don't need to give any information. Like, for example, I know at my daughter's school, I know they have an obligation to tell us every time there's a COVID case, and unfortunately there's been one. And I know it was in grade 2, but I don't know who it was. And I don't know anything about it other than that there was a COVID case in grade 2 and they shut the class down for 2 weeks, but they didn't shut the school.
Okay.
So again, it just goes back to my point about privacy.
Yeah.
Issues being less important than public health. They've made that choice, and you can see it with the vaccine, by being allowed, by forcing people to show proof of vaccination. The government has said, well, we're not too concerned. Or if you want to keep your vaccination status private, you don't have to show anybody. You just can't go into the office or to the Leafs game or Jays game or whatever else.
Mhm. Okay, well, with that, Matthew, leading up to 2:00 here, we are at the 2:00 wrap up time. So just want to say thank you so much for your
Thank you.
advice, for taking this last hour to answer all the questions for our
It was
participants.
my pleasure. Thank you.
I really found it so valuable. Your contact information for anyone who is looking for employment counsel, please feel free to reach out to Matthew. If anyone has general questions about what Humi is doing in the workplace, feel free to reach out to myself as well. And I'll also take this time right now to talk about the next slide, which is our upcoming webinar around the new compensation strategy and how a retirement plan might be your secret weapon. Humi is partnering with Commonwealth, and that is taking place on October 28th at 1 p.m. Eastern District Time. So please feel free to sign up and visit humi.ca/webinars for more information. But thank you again for everybody participating. Thank you again, Matthew. This was tremendously helpful, and I hope you have a great rest of your Thursday.
Thank you all. Thanks, Andrea.
Bye.